Okay. And hello and welcome to DaleSchaferLaw Chats, a candid conversation with industry professionals on complex legal and business issues in the cannabis industry. I am Heather Schaefer, legal assistant with the Law Office of Dale Schafer and CEO of Agorasi Business Services. And you all know attorney Dale Schafer, 2-decade California cannabis attorney with a current focus on cannabis business law. Today we are chatting, I'm so excited. Today we are chatting with attorney Luke Zimmerman, who is just an awesome individual. And we're going to, today's topic is intellectual property in the cannabis industry. Just as a disclaimer, please be advised that today's topic is not and should not be considered legal advice. We're simply offering a unique and informative conversation between two professionals about issues within the cannabis industry. So Luke, tell us about yourself.
Hi, I'm Luke Zimmerman. Thank you for having me here today. I'm really looking forward to talking to you guys about intellectual property. My background goes back to Wisconsin. I am from the farmland outside of Green Bay, specifically around the Deep Pier area. I have had a relationship with cannabis for close to 25 years now. Through that, it's taken me a lot of interesting places, but it got me to move out to the West Coast. And I lived from Seattle down to San Diego. I went to the University of Oregon, got a philosophy degree, moved down to San Diego, got a legal degree from Thomas Jefferson School of Law, then ended up moving to Amsterdam to get my first master's of international law, focused on international trade and international investment law. I wrote the focus of my thesis on international harmonization of intellectual property rights, especially as they relate to the TRIPS agreement. Then most recently, I just found out actually last week, I successfully completed my second international master's of law, which earlier this year, I took classes in Turin, Italy through the Turin University and the ITC-ILO, which is an international labor organization that has direct ties to WIPO, which is the World Intellectual Property Organization. And so I got a second master's of law focused on international intellectual property issues. And I did my research there on international classification through the NICE classification system and how it relates to cannabis and hemp goods and services, and how we do trademark classification at the international level, and how there's a need for that to be further developed. So that is me in a nutshell.
Okay. Well, what I normally call you about is I got a client who needs to register a trademark or who needs to get the PTO registration going. So let's start there. And let's assume that I have a client who's been in the traditional market with a brand.
Right.
And they want to move forward to have their brand legally protected, and then to be able to have that brand go into the legal cannabis industry. Where does that discussion start as far as securing their trademark rights?
First question would be, when we refer to the traditional market, are we talking about they operated under 215 and then have stopped operating because they are anticipating that they are going to engage in the legal cannabis industry? Or this is something where they've just been kind of existing without a license since the medical days have ended? What does that scenario look like?
Well, let's assume they're continuing to run their brand and they're not legal.
Right.
Okay, so let's start with that one. What would they do?
So I think you're going to be in a situation where, especially if you've come out of 215 and you're still using your brand, if you will, you're going to have a lot of obstacles because you've kind of actually built a case against yourself for the BCC. You've built a body of evidence potentially of how you're using the trademark illegally, which arguably it's not even a trademark then, because one of the requirements for a trademark is lawful use in commerce. So in a scenario that would look like that, you would be trying to seek trademark protection on something that is not protectable because you have to have a lawful use requirement. So even though you're using the mark in commerce, it's not lawfully used, so no trademark protection. Then we'll go forward and saying, well, you're in a transition point where you're trying to move into, get your license or move into the legal market. what's going to happen is you've created all this body of evidence where if you ever get audited, so you're like, oh, now we're not doing any more traditional activity and we're now just focused on, we've got our license and we're just going to move forward. All of that, if there's still product that's still in the black market or in the traditional market, you're going to have an issue, especially if all of them are non-compliant. So you would be in a position where you should be sending cease and desist letters to anybody who's carrying these products if you're trying to enforce your legal rights. But arguably, you're not going to be able to really rebirth it if you have that much association with illegal use underneath that mark. If that was a potential client coming to me in that situation, I'd be encouraging you to create a new brand and create a new trademark, something that is going to be completely through this legal license. Everything is compliant with the state. By not doing so, you're creating all this liability that's hanging out where you just got your license, you spent all this money and time going through the process. It's a headache. We all know that. And then only to have like this history part get dredged up potentially in a way where you can't ascertain what that liability will look like or how it'll come up. I wouldn't do that with my business, or I wouldn't do that with my license if I were in that position.
So let's assume that we're starting from scratch. I've got my license now. I want to get a brand. I want to protect it. The condition precedent has got to be used in commerce, and that's going to be legal commerce. So they have to start something. What's your advice on getting started and then moving towards trademark protection? What would that look like?
A client or potential client in that position for me, that's like an ideal position to start addressing these problems because we don't have the backlog. What I try to work with clients in that regard is, one, the phrase never get married to your trademark. You might consider getting married to it after you have a complete registration, both at the state and federal level. But until that occurs, don't get married to it. And so if I have a client who comes in and says, I have this one brand, this is what I'm doing, we can explore that option through doing clearance searches to see if the trademark is potentially available. But ideally, it would be maybe you have a short list of like 3 different trademarks you're considering using. So then we can explore those doing clearance searches to see if they're already occupied, which, as a quick segue, there's a lot of trademarks that have been occupied already in the cannabis space, let alone if you start thinking outside of just California and you think nationally. Trying to find a mark that maybe has some association with the cannabis industry and is not already occupied, very hard right now. And one of the new trends we're seeing is actual litigation around trademark infringement. So making sure that it's free and clear as much as possible at the beginning is going to save you a lot of money and headache in the long run. But that's the first step is, okay, here's a short list of names. Let's look and see if any of these are viable. There's a few different ways that can be done, from different, like you can do a deep dive, like a full comprehensive search, or you can kind of do a more of a quick and dirty knockout search that just sees if there's any glaring red flags. And so from there, come up with a strategy of how to do some potential federal registrations for ancillary goods and services, because federal trademarks can be filed before use in commerce with an intent to use location. But get those started, and then as soon as you have the first date of sale or first date of use in California, we file those state trademarks on that day.
Okay. So at the federal level, this is the PTO, the Patent Trademark Office.
USPTO.
And what you have done with people we work with in the past is you go register, like apparel, other items. So can you explain what that means?
Right. And the apparel reference, that's one of my least favorite filings to do for clients, unless you legitimately are going to have a product line of clothing. What I found, especially from, we'll say 5 or 6 years ago, there was a lot of trademarks that were filed just for apparel, and I think either misinformation was given to the client or the client didn't understand what that protected. But there was a misplaced belief that, oh, well, I have this trademark registered for clothing, I'm good everywhere else. That's not the case. The clothing, if you are making like a full lifestyle brand or this is not just going to be about cannabis, we're doing all these different things, then it really has a place. But if it doesn't, there are better classes you can focus on that are probably more related to information services. There's some creative stuff you can do with hemp now, especially if you're, due to the Farm Bill, the 2018 Farm Bill, and legalization of hemp, you can actually get a fair number of hemp-related federal trademarks at this time. And a lot of those classes are going to be the same classes that you would use in the future after prohibition ends for cannabis. So there's some strategies you can do there that I think will have long-term benefits as well.
Now in California, once it goes into the commercial space, you can register a trademark. Let's talk about that. What is involved with doing that?
Well, you just want to show that you've had use in commerce in California, so ideally a sale, or maybe you've started to do advertising, but really there should have been some exchange of money for either services paid for on the basis of the advertisement, or even if you're selling from, you're a manufacturer and you've sold to your distributor and it's not necessarily on the shelf yet, but you've used this in commerce. It's gone from the original point A of where it's the owner out into the world, and there's been some exchange of money, then you could file the mark. Did that kind of answer your question? Yeah.
Well, it does. California allows the trademark to be officially registered if it's a cannabis brand. That's
yes.
Yes.
And so that's a big difference from the state to federal. So yes, at the federal level, cannabis is still a Schedule I narcotic under the CSA. So you cannot register a trademark at the federal level because it will fail for the lawful use in commerce requirement. Whereas California has amended its state trademark laws to start accepting cannabis trademarks as of January 2nd, 2018. Many other states have done this as well. So there's usually, if you want the most comprehensive strategy for protecting your trademarks right now, you're usually going to be doing a twofer. And arguably a threefer, depending on the scale of what your business is. And that will be, you're going to be doing state level registrations, you're going to be doing federal level registrations. And the threefer that is not talked about as much as I think it should be, and it's not a one size fits all, like maybe if you're a small cultivator, this is never going to be an issue for you. But if you're a medium-sized company that has traction, looking internationally at what opportunities you can do for trademark registration, because internationally there's different jurisdictional requirements for doing trademark registration, where sometimes it's actually easier to register your mark, even if it's cannabis related in other countries, especially Canada. Canada probably has, I think it's CIPO, C-I-P-O is their equivalent of our United States Patent and Trademark Office. And if you look, their trademark manual has been updated to identify cannabis goods and services. So they probably have arguably the most comprehensive trademark identification manual right now in the world. So doing registrations into Canada, much easier. They also have a different requirement for use, where a number of countries you can file the application and you kind of hold your place in line. You should use the mark within the next 3 years of filing, but it's a lower standard for the obligation than it is in the United States.
Mm-hmm. One of the things that we're doing now is white labeling, if you will. And on the contracts I'm dealing with, what the licensed business wants to see is an assurance you have the right to use the trademark, if you will. You're licensing something you have a right to do.
Right.
So if I represent, say, a distributor,
right,
who's going to package and put your material into packages and move it down the supply chain, and you don't have that right to use that secured yet, what kind of problems is that going to develop for these businesses? What are they looking at the downside if these cease and desist letters come out, or the state comes in to stop them? What does that look like?
I mean, that's not even just a one answer. There's a multitude of ways for that to go wrong, especially like, is this an exclusive license that you've been offered? Is this a limited license? There might be different indemnification requirements where if you become aware that someone else is using the mark, who has to enforce that there's some form of ownership? That's why if you're going to do licensing agreements, I would not engage a licensing agreement unless there is either one, a proper recording, or two, written into that agreement, there is some explanation of how a recording is going to happen, and then a clear understanding of who owns what. I think sometimes that gets glossed over too quickly, and that can cause anything from naked licensing agreements where there's not actual ownership of the mark anymore, because trademarks function as source of origin indicators. And what you want to be able to do is when you look at that trademark, you can clearly draw it back to who owns it, who owned the goods, or who provided the services. And as soon as that gets muddled and gets confusing, the actual both value and then independent ownership of the trademark gets called into question. So I think, let alone there's obligations for recording to state agencies. I mean, specifically for California, the BCC is going to be want to be aware of licensing agreements. If you're white labeling for someone who doesn't hold a cannabis business license, there's massive implications for that about how that person is either listed on the license holder's license. Also, I mean, the reason for that is trying to get around background screens. But the BCC does not want people who are not screened to be deriving benefit from commercial cannabis activity. So that's something that needs to be taken seriously. I think is getting overlooked a lot of times in the industry right now, and not necessarily audited either right now. So I think that this is a potential landmine for future audits. So there's a multitude of ways that can get messed up, or the concept of, if I'm licensing to you and you're a distributor, or we'll go with a manufacturer scenario. I'm having you make edibles for me. Here, I'm licensing you my trademark. Now, if you're actually also white labeling for, say, 5 other companies where you're making their edibles, if there's some issue of products liability that arises from the facility, I don't think there's a good understanding yet of how that bleeds out to all of the other relationships for all the different licensees or licensors who are licensing with you as a licensee. That I think that needs to be contemplated. Instead of just like, oh, this is easy and let's just get it done. You have to have an understanding. I would want to know from the manufacturing side, who else are you manufacturing for? Are these businesses that are potentially look like they have integrity and they're probably keeping up with their state obligations? Mm-hmm. Because the potential bleed over for that is very real.
Mm-hmm. Well, we basically demand financial interest holder declarations. I mean, I do some work on the outside supply chain, right. And we build into these contracts warranties that someone's going to make, which, you know, if you don't have this, you breach the contract. But then beyond that, how do you ensure this? Because the product's liability part of this is somebody gets hurt or somebody gets sick or something happens from your product. But the other part of this is that you run into somebody that's trying to steal your trademark. Right. Who is going to be responsible to go out and try to enforce that? And as you and I have talked many times in some other work we've done, who is going to go out there and protect your whatever this this thing you've licensed? Who's going to protect that for you? Because if the state licenses you and there's unfair business practices that's going on of trying to steal somebody's trademark, then it's real confusing. I mean, the state is supposed to go do this, but who's going to pay for that?
Right.
How does that get actually done? And I'm still trying to figure out these contracts myself, because some of the things you've touched upon, I've had discussions with. If it's only in California, it's exclusive, it might be a little bit easier to keep track of this. But if you've got multiple licensing agreements going to multiple places, right, and they don't fulfill, or they fulfill inappropriately, or they package wrong, and it's going to be recalled. I mean, the downside of this is horrible if it doesn't work out just the way you want it to. And I don't have an answer for this. I'm just,
I think you
things to talk about.
That's what oftentimes is not considered, or what I've seen in the industry right now, is the potential liability that is created. Usually it's the the dollar signs are seen as potential revenue generation, or hey, this is going to be an opportunity, without fully contemplating that you're potentially putting your license at risk by entering into this relationship. And this can explode into litigation, which is expensive, or if something improper happens, maybe that comes back and you're not allowed to operate. But for terms for licensing agreements that you really want to make sure that are there are, one, identify who owns what. Two, you want to make sure that there is a clear definition of what territory the licensee has a right to operate in. And you can restrict that. I mean, if you're writing, well, it's everywhere in the universe, that's going to get really problematic if you do another license that says the same thing, because now your licensees might come into conflict with each other in their own market. You want to have something that asserts some form of standard and control over how the trademark is used. Arguably, that's a Goldilocks situation, because if you have too much, you can have unintended consequences with potential franchise issues. But you need to have enough to show that you're actually monitoring the license agreement or the trademark license agreement. I think that is a major issue that's going on right now as well. And I think because this is so infantile, and we don't have a lot of great examples of how this has been tested, some of the fast and looseness of it makes me really uncomfortable. That I think there are some issues or instances where people are creating what looks like a great distribution chain or a great use of their trademark, where in some cases they might actually be eroding their trademark rights. And because, once again, going back, trademarks function when it's clear and distinct, they're a source of origin indicator, and you can go back and say, well, clearly this company owns it. If that gets muddled, the overall value of what this trademark is, or even the enforceability, more importantly, gets called into question.
Well, I was an insurance defense lawyer, so I look at insurance policies or lack thereof, and that's how business operates. If you don't have insurance to cover things, all it takes is one oops and you're done, because you can't afford to handle this. Have you seen any policies out there that you think are inclusive enough to handle a white labeling agreement outside the chain?
I only have so much knowledge about insurance, not my forte, but I will say this. There are insurance providers who are offering intellectual property insurance into the cannabis industry. And I have not seen many people go for that, but that is something, especially if the valuation is heavily in your trademark rights of your company. And if you're going to do multiple licensing agreements, you probably want to contemplate that, because if your policy just for running your business does not cover these issues, that could become very expensive, especially if it goes sideways with your licensees.
Well, some of the inclusions that I've seen in these contracts are a CGL policy with a product's rider. Okay, that's anticipating you're going to hurt some person out there, the customer, if you will, with your product. But I haven't seen them that protect a recall because there's a pissing match over the intellectual property rights or something like that, or cease and desist comes out and you get an order from the judge, you have to stop the supply chain or perhaps bring them back. That's where I'm seeing a huge hole in this, because if you spend all this money to protect these rights and somebody tries to diminish the value, and you don't have insurance to go spend $200,000, $300,000, $500,000 to litigate these cases, and that's, people shit themselves when you say it's going to cost how much. Well, I'm telling you, $500 an hour minimum to hire an attorney who knows what he's talking about here. They're going to drop a bill on you for six figures, multiple six figures.
Discovered.
And so now, where's the value in this?
Multi-state, where all of a sudden you're like, oh, well, we got to have a firm understanding of how many licensees do you have. We need to review all that. How many different states are like that? That can balloon very quickly. But I think for having you identify it as a whole, honestly, intellectual property rights, from what I've found, are oftentimes thought about very second or third or fourth, or not even considered. And that is really problematic, because intellectual property the rights are generally best asserted if you have a solid foundation. It might not be the first thing you consider with your business, where you need to have an entity, you need to have an operating agreement, you need to understand how you're going to house the license, but they should be contemplated pretty quickly after that. Even speaking to the point of, there's so many operating agreements that get drafted where in the idea of dissolution, it doesn't contemplate what happens with your intellectual property. So if you have the breakup, who gets the trademark? Does it just get dissolved, or is this going to get auctioned off? And if at times that's the most valuable part of the company at the time of dissolution, that can get really ugly. Let alone if one of the party members wants to carry it on and, you know, still use the mark after the fact. So I think that this is just something that is not contemplated as much, often because as an intangible right, people just have a hard time wrapping their head around what that means. I've seen and I wouldn't expect anyone to have a high understanding of this if they've not experienced it or worked with it, but it does seem to be kind of ethereal or esoteric, even for other attorneys, where they're like, okay, well, you know, I'll use an example. I have a client who, and this is a hypothetical, this isn't, who would say, I've been cultivating this plant for 15 years. I'm the only person who has these genetics. I know it because I haven't even sold it to anyone else. This has always just been for personal, but I think I got this thing that it's gold. It's amazing. So I own it because I made it. And here's the seeds. You have a physical property right because that's in your hand. That is a tangible right. Any of the underlying right around maybe restriction of propagation or ownership of the genetic code of that plant, you don't own that. The only way to establish that is through a recording, and especially in the case of plants, all of those, there's 3 different ways to do it in the United States. All of them require a federal recording, be a utility patent, a plant patent, a PVP registration. And some of those aren't even accessible for like cannabis as a whole right now. Hemp is a lot more accessible, but PVP isn't even accessible for cannabis right now because you have to do a submission of live seeds. So I think a lot of people just don't understand what goes into this, and I understand why. I mean, I spend a lot of time studying this, so I get it, and it is very nuanced, but it's just oftentimes overlooked or not contemplated.
Well, one of the things that we've already been asked to do is some new states came on board. So we've got inquiries from Mississippi and South Dakota.
Right.
And California and perhaps Colorado are the places where we've got brands that are being driven and gaining value. But if you go into a new location, a new state jurisdiction, and you bring your brand there, that's where things get beyond esoteric, because now you've got to learn all their intellectual property rules in that state, because there is no federal bridge across all of this. That's where I just see what little hair I've got left, I'm going to be pulling out, trying to figure this stuff out.
There are ways to plan for that. And going back to the strategy of, if you're talking about trademarks, you know, you want to have a good state level strategy that that's going to change state by state, but you have something in place where you're going to be enacting it while you're still working on a federal level strategy. So you have something that you can arguably enforce at the federal level that is for a legal federal purpose. If you're in the realm of patents, you're going to be doing registrations for patents, and they should be allowed to be litigated in federal court. There's some scholarly minds that debate still if you can really have a firm judgment based on a cannabis issue in federal court. Copyrights, you don't necessarily have to record at the federal level, but if you want to enforce them, you do. You have an innate right, artistic right, purely by the virtue that you created it. Trade secrets as another form of intellectual property, that is more about internally how you have an SOP that explains how you preserve the secret. And there's federal right for that, and there's also state level rights for that. So I think you don't have to tear out your hair, the remaining hair you have, because there are ways to address this, but it has to be contemplated early, because trying to work backwards after there's an issue, some of these, like in the instance of trade secrets, if there's already this was misappropriated and, you know, a couple of other people know about this, trying to establish that it's a secret, you can't really work backwards for that. Or in the case of patents, where you're like, oh, well, you know, I only gave a handful of my friends these seeds and they're propagating it, but now I want to record it and I don't want them to use it anymore. That ship has sailed. You're probably not going to get that back. Or if I'm using my trademark and I've got friends in 4 different states and they're all using my mark too, but it's cool because we've got a handshake deal and they know that it's mine though. And I mean, and they start having success. Well, who really owns it? And are you going to get paid? Let alone can you enforce your right? So all those things really need to be either taken care of through doing recording. Ideally, as your company grows, have an internal SOP of how you're going to manage these things. But make sure you're doing recordings, and then any of the transactions that you have going outward from your entity, make sure that there's a paper bridge to explain why you're having these relationships. And you can point to these terms and say, okay, well, this is how it's able to be used, but there's an understanding that I'm still the owner of it. So it can be done, but it has to be contemplated. If it's contemplated after the fact, that's when it gets extra expensive, or if it's sometimes just not doable, not enforceable.
I recently ran into a product that the owners of the product were really trying to be secretive about it. And, you know, I got on the phone with them. I said, look, in California, I can reverse engineer your product.
Right.
And then I can then start selling that product. I can't use your name, stuff like that, but that product I can reverse engineer. And these people about shit themselves. It's like, well, there's a handful of states in America, the United States, that allow you to go reverse engineer, and then it's no longer a trade secret because I untwisted the slinky, and now I got it. And I can't call it Kentucky Fried Chicken, but it's all your magic little recipe in there. So there's layers of this that I could take a product that I can't do this in some other state, bring it to California, reverse engineer it, call it something else close, but I might even be able to say, we reverse engineered, you know, Kentucky Fried Chicken, and we're calling it, you know, Carson Fried Chicken or something. Right. And it's the same thing. They can't stop you. These are the kinds of, it's esoteric until someone steals your recipe and you're trying to go protect it and you can't.
And that, yeah, I think it gets a lot more personable, where all of a sudden you see where the revenue is being diverted from what you plan on making. And you're like, well, that is my thing. And that's when you start all of a sudden being like, well, do I own that thing? Or why do I think I own that thing? And how do I plug that back up? And so, especially around reverse engineering with trade secrets, that's a hard one, because a trade secret is oftentimes something that could be accessed by anyone in the public. And Kentucky Fried Chicken is a great example of this. Herbs and spices, any one of us can buy those. We just don't understand the ratio. We just don't understand exactly how do you do the recipe. Could be figured out. And at that point, the point of protection for Kentucky Fried Chicken is their trademark. It's not going to be based on a trade secret anymore, because if the person alleged, well, I figured out your recipe, my response to that, if I represented KFC, would be, no, you didn't. And that's not the same thing. And it's inferior. If it came from someone saying, well, we reversed engineered it after someone had been exposed to this information, especially probably through some confidential conversation, that becomes immensely problematic then for the person who's claimed they reversed engineered it, because maybe you didn't. Maybe you just lifted the recipe. And then that's where litigation around trade secrets gets really dicey. And so if you're contemplating licensing trade secrets, that litigation can get very expensive if the relationship ends of like, are you still using the trade secret that was licensed to you? Or have you come up with something different that just looks similar? That's where that gets very expensive. And also, once again, needs to be contemplated early. Otherwise, there's potentially nothing that can be done. So working in non-disclosure agreements, having procedure for that, especially if you're going to share confidential information, non-compete agreements, which in California generally are not enforceable, but there's actually an exception specifically for trade secrets, which from my understanding, that got most often used, especially during the .com era, where you had software engineers who were kind of hopping around between companies. So California is willing to enforce non-compete on some level, especially if you can show that it has a direct relationship to a trade secret issue.
here's a discussion I had within the last week. Somebody wants to set up a nursery, and they've got all these strains that they developed in the black market,
Right.
and they want to set up their nursery and start selling their strains, if you will. I mean, I'm not sure that term really works anymore.
I was going to run that into the ground. They don't have strains. Strains don't exist. There are no cannabis strains. There are cannabis cultivars. There are viral strains. There are viruses and strains, or if it's a genetically modified plant, then there are strains. Other than that, it's only a cultivar or a varietal. And so,
what he really didn't like to hear was that, well, when you bring something from the black market into your operation, how do you get it in your inventory? Because in California, January 1st of 2018, they said if it's in your inventory, now it's in the stream of commerce.
Right.
But if you're developing this out in, the black market gets a lot of people upset, but the traditional market, whatever you want to, there's a lot of breeding going on out there, a lot of things being developed. And I was talking specifically about some old school strains I'm aware of. I've got a lot of friends continue to cultivate in the medical world, the individual medical world. These less high THC strains have more cannabinoid profiles to them, terpenes profiles. For old farts like me, that 30% THC makes me lightheaded. Now what do? These are old school strains. How do you get them into the commercial cannabis industry if it's pretty easy to show they came from the outside world? Have you dealt with that before?
I mean, if you legally, we can possess and gift cannabis and cannabis seeds in California. So if I was gifted 5 seeds, and I started propagating based off of that specific cultivars, feasibly that could end up in the commercial realm. I believe that there is a way for that. If I am selling without a nursery license thousands of seeds of these specific cultivars to get them into the recreational or adult use market, that would not be allowed because you're driving commercial profit for something you don't have for licensed activity. I think the idea of these cultivars that you're talking about, especially low THC cultivars or middle of the road THC cultivars, the idea of exclusively owning those things, those probably don't even qualify for plant or utility patent protection anymore because they're not novel or new. They're old. They've been used in the marketplace. They've been disclosed. So in cases like that, so we'll say that these are gifted or this is legally been moved into the market probably through some format like that. Then you're probably going to want to try and build a brand around these cultivars as opposed to, and through trademark protection, as opposed to thinking, well, I'm going to exclusively own the genetic stock or the genetic identity of these plants. Because that's, especially if they've been around for a while, that's not going to be, that will fail on requirements for recording a patent. But yeah, trying to convert something that has been in the historic legacy black market, however you want to call it, into the recreational or adult use market. I know a lot of states had the concept of this immaculate conception of genetics. I know Canada did too, and I think actually Canada still does when you get your license, where you have a narrow window of time where you have to formally disclose, here are the specific cultivars that I'm using and I have, but I'm not going to be asked where they came from. And I think that there are probably the best way to get older genetics in California would be through the idea of just a gift and say, okay, and it's got to be small quantity, not for the purpose of commercial activity. So, I gave this to you, you do what you want with it now. But as soon as you start accepting a financial compensation, that gets really problematic.
Well, and Metric has some issues about, identifying if you're going to do an actual seed production grow, what are you going to put into the system to say these are the plants that I allowed to come in? That's where we start getting creative. It's like, well, you have a seed production run, and when the seeds come out of it, those seeds came out of a lawful run. And what you started, you know, it might be somebody gifted me 5 seeds, 10 seeds, handful of seeds, whatever.
Oh, yeah.
You just put them in a greenhouse and let them do what they do, and they came out with bags of seeds. Now that's in the metric system. And I mean, I'm not saying that that's the final answer, but we're trying to get creative here about how you
If you
would do
wanted
that.
to be really creative about it, and legitimately you have a nursery license, what I would seek is the pollen from these old cultivars. Because from I haven't heard of anything about controlling issues for pollen.
Yeah.
And then I would just go in and propagate my own line, which is new. It might be based off of the old genetic stock, but I'm doing this thing different. And I would have probably whatever I'm breeding it with be a very stable cultivar. And then, I mean, and once again, I'm not a botanist. I don't know how to do breeding, but that scenario sounds like what I like. If you wanted to be as compliant as possible, the only thing that would be outside of metric would be pollen. And I think that's probably the safest way to bring that in if you want to be as compliant as possible.
Well, now I want to spend some time on the subject you and I got deep into, was terroir.
Okay.
And especially the international aspects of this. And you and I both teach at Oaksterdam, so we run into people there that are out in the world. And I had a couple of students come to me and tell me they were paying 100 euros for, you know, a dime bag of garbage here in California.
Right.
They were paying 100 euros for it. So the value is there. California has that name, you know, recognition. And a lot of work that we did on the terroir was to try to describe what is unique about it related to the soils, and a lot of it was the triangle area.
Right.
So let's see if we can unpack some of that so people would understand how taking a named product here from, say, California, and when the international barriers now lighten up, how that gets to Europe, what that means for protection in Europe, so that if you're thinking about this, what the future is going to look like for that. So let's.
So you're
actually, you talk about that for a minute.
You're talking about the concept of geographic indication as intellectual property, and then as a subclass to that, appellation of origin. Geographic indication really is the enforceable mechanism for it is the TRIPS agreement through the WTO, which is the agreement that harmonizes intellectual property standards internationally for members of the WTO, member countries. And if you think about it, if you're not familiar with this term or concept, Idaho potatoes, Florida oranges, Washington apples. The United States as a country doesn't really use geographic indication that much, as opposed to European countries, say like France, Italy, Spain. They have a prolific amount of use, especially as it relates to cheeses and wines. We have a different system set up for wine, or the ABA system, which is more akin to appellations of origin, whereas appellation of origin isn't really contemplated in the TRIPS agreement. There's a separate international treaty called the Lisbon Treaty, which the United States is not a signatory to, which means we're not part of, so we don't have anything that really directly relates to this. The Lisbon Treaty more recently has the Geneva Treaty relating to appellations of origin. And so there's, I think, currently 23 countries, but think about it, there's a lot of different silos here, right? What California would be best served from is if we had federal prohibition end, then the federal government goes to bat and says, much like Florida oranges, we want California cannabis to be identified as a geographic indication that protects cannabis cultivated in California. We assume it's a superior quality product. We're going to include that in our treaty obligations and enforceable around the world. Ideally, that would be the best case scenario. We're going to have to hold our breath on that for a while. What California has done recently, and what we've been working on a lot, is the appellations of origin program, which is unique because appellation of origin is not really used as much in the United States. our only correlative for that really is the AVA system for wine. So what California is doing, especially through the CDFA, is very unique. We are creating sub-regions. So think about it where geographic indication might be the entire state of California. Appellation of origin is small regions contained in the state of California. And those regions will be producing cannabis in the soil under native sun that should be able to be shown that the end product has a characteristic or some relationship to that that's unique to that region. The problem with this, whereas I think it's a great, I love that California is doing this. I think it's going to be very, it showcases California cannabis and these specific regions of California in a very unique way, is the upstream that if we have substantial success in California, I am more optimistic and would like other states in the nation to replicate this model or implement a model similar to this. Whereas trying to pierce into the Lisbon Treaty, which is, think about the silo over here, which the United States is not a signatory to, we would have a hard time trying to assert some form of appellation right when we're not even a member of the legal treaty that is able to grant those rights. So I see it as a unique opportunity. I love that, as I said, I love that California is doing this, but I think if we draw it out, there's going to be some obstacles in the future as we try to permeate the international market. If anything, some of these other countries that are already members of the Lisbon Treaty would probably find more success if they started cannabis appellations, because they're able to move those appellations through the Lisbon Treaty system a lot more efficiently. Yeah, so I think there's two things to consider, going back to it, just geographic indication, which is gonna need federal support, which I wholeheartedly hope the government, when it finally moves past prohibition, is aware of this, because it is an immensely valuable cash crop for California that does have a cachet of identifying that there's a superior good around the world, because I've heard similar things that, you know, there are, what do they call them? There are clubs officially in Spain where they'll have a shelf where they'll just say, hey, this is California cannabis, which probably is from cultivars, seeds that are specifically California based that ended up there. So I think it's a new form of intellectual property that's being explored. I think that we're going to hear a lot more about appellation of origins, especially for California, over the course of the next 2 or 3 years, as that system gets in place and is implemented, and you have small groups come together that want to have an appellation of origin designated and identified by putting forth a petition. And aspirationally, for me, what I would like to see is states like Oregon taking this up and saying, okay, well, you know, Southern Oregon is known for cultivation of cannabis as well. Maybe they'll adopt the appellation program and start putting appellations in place for Oregon, because collectively, if the more states that we have implement some version of this system, when we do have prohibition end, that will be an easier pill to swallow for the federal government to say, oh, look it, you've already made these. Let's figure out how to assimilate this into our law. Whereas if California is the only one that has done this, the future of this project, I don't know where that goes, because if the government says, oh, cool, I mean, we'll acknowledge this, but we're just going to acknowledge it as a GI. So California cannabis, cool, you're good. And then all of a sudden, all these appellations that have been established saying, well, no, we need to still have this identity and we want to preserve our right and we want to be able to assert it. If that isn't acknowledged by the federal government when we do have prohibition ends, there's potentially a lot of room for work that will have been wasted, or a lot of frustration, because it'll just never be acknowledged. It won't have the opportunity to grow. So I am a little bit less concerned about how this looks at the end all be all at the international level, and much more concerned about how we can have this trend catch on in the United States.
Well, one of the discussions I know that we had through this process, as they started to bring in the objective factors to be able to dial in what it means to be an appellation of origin, you've got the cultivars. We can objectively quantify what that is.
Right.
The atmospherics, the meteorology, the geology, the soil conditions and things like that. We can go test that. Where I kept getting tripped up was the human factor part of this.
Right.
And I'm not sure that my anxieties have been assuaged, because when we talk about the AVA and they use the term appellation, then it's more of a geographic indication and a trademark for a particular area than, oh, the soil in this particular field produces this level of something objective in the grape pressings that then goes on to have a unique bacteria in the cave where we store this. I mean, when you go over to Europe, and again, I'm a historian, so I went back and looked at the Napoleonic period as they brought forward, let's see if we can capture Roquefort cheese and Burgundy and those kinds of areas where there were traditions of doing things in certain ways. Okay, and 200 years ago, the science was just not there. It was, this is our history. They can now go to Roquefort and find there's certain bacteria in the caves, there are certain conditions. So they have that tradition in Europe. In the United States, we don't have that tradition. It's more of an objective. What can you prove? I got a picture of your trademark, the colors, the design. If you try to, appropriate that or misappropriate that, we have something to look at. It's still the objective part of this I don't have a problem with. I'll put an expert into the witness box and examine them about why we've got X, Y, and Z, and it makes this product. I still am struggling with the human factors part of this and the belief on people that growing in some field in some part of California makes this something that objectively I can't quantify, but I believe it's got value from that. That's where I'm still struggling.
I get it, but think about this also, if like for the Roquefort cheese example, right? Where we'll go, there's a multitude of cheeses that are aged in caves, right? The cheese didn't end up in the cave on its own. People put it there. And so those are the things that'll get quantified in the petition of, here's the tradition of how we do things. Here is how we agree in this region we do things. I think stretched out, because we will dig more into soil sciences. We are going to be looking at the environmental factors, but there are certain things that cultivators in those regions might be doing that are different than cultivators in other regions, because they're responding. It's the relationship between the environment and the intention put forth by the person who makes this unique product at the end. So I'm optimistic about that sense, just in that people will have to very much define and explain what that means. It can't be so ethereal where they're like, oh, we just grow really quality cannabis. It's, well, why? What are you doing that's unique? And how does that relate to the earth or the environment? And I think that, I mean, it poses a challenge, but it also, I think, kickstarts a lot of room for doing research into this plant in a way that hasn't been done before.
Yeah.
And I think there is a little bit of I wouldn't say a misconception, but the value of appellation of origins is not year one or year two, especially as we have closed markets in California where we're only selling, from Arcata to Temecula or Arcata to San Diego. It's more so, year 15, year 20, year 50. And by then, ideally, we're going to have an international market. And that's where, after it matures and you can say, well, this is the tradition that we've been doing for this extended period of time, and this is why, and this is the identity of the region, that's where the payoff is. And some of those ideas might be challenged as it goes along. But I think the human factors, it's going to be more so articulating, well, this is what we do, what we do, and this is why. And then we'll have the more objective or testable factors that fill in behind it. But you need to articulate what the identity of that region is and say, we have this group that does this. It's not, well, cultivator 1 does this on his property, but cultivator 2 doesn't do it. That's not an appellation. It's going to be, well, consistently, these are the practices that we do that have a relationship to the environment. And that is why we have this thing that is an identifiable good or has an identifiable characteristic that is shown through these practices and the relationship with the earth.
Well, one of the things that I've observed, going around the state, is that there are different climate zones in California, and a couple of them are light years ahead of the rest that are still in the black market.
Right.
So the cultivators I know up in the foothills where I live, this is a Mediterranean, dry summer, cold winter environment. And so when someone will show me a cultivar they're using and how it turns out in this environment, if I go to the Triangle or I go down the coastline to Monterey, where there's a wetter environment, and perhaps those cultivars either don't grow there or they're not as tight and the biomass is different. And so what I'm interested in doing is that once we get the entire state opened up, and we have the agricultural colleges we're in cooperation with us,
Right.
that you can look at the entire environment, what cultivars seem to be successful there and why, and then we can educate the world about why certain strains grown in Humboldt County are going to be different than those grown, say, over where I live in El Dorado County, where there's no moisture. We're down less than 10% for the vast majority of the year. So you don't have the same biological problems of mold and mildew that you have over in the coast.
Right.
And try to see if we can focus on that. It's still way early, and I tend to overthink these things a lot, because you try something from someplace and you go, oh, that's just wonderful. What is that?
Right.
That same strain grown someplace else, it doesn't have the same effect.
Well, I think there is still so much confusion about actually identifying what the plant is. So actually having distinct and unique cultivars, that's still a hot debate on how we're going to do organization around the plant, because I do think that there needs to be more research around this. I mean, if you look at Leafly, it looks like there's hundreds, if not thousands, of cultivars. From talking to people who work more in genetics, they're actually like, the gene pool is really thin. These are just different names that are being put on the same plant. And even if there's a certain variation of chemovar or cannabinoid expression, it's really the same plant that is just responding to how it was grown, possibly environmental factors, possibly human condition. So I think that needs to be fleshed out more, and I'm happy that research is going on. I know Oregon has a university working on it. I know that there's some researchers in the Caribbean who are working on this, which I think is really exciting. Me, and I like, for thinking of the long term, I like that you think about the long term too, Dale, because like if you don't contemplate potential problems, trying to respond to that problem when you just encounter it like it's this new thing, sure, that happens in life, but if it's something that could have been foreseen, just trying to like ignore that was a possible issue, I think that's a foolish way to go through life. But what I consider for these appellation regions that I would like to see long term is, after they're developed, you're going to have some business structure entity, right? And they start identifying, well, these cultivars are really unique for this region. Then ideally, in my perfect world, you're going to have propagation go on where they are creating their own cultivars, probably based off of successful genetic stock. And then at that time, this new creative entity is going to register some plant patents or utility patents. And then that region will have the exclusive genetic ownership of those plants, which then builds on to the identity of that region. And maybe they add more cultivars like this as it goes on. So whereas we look at regions that are wine associated and they have these, the specific genetic stock of grapes, I think we could see something like that stretched out far enough for cannabis appellations. It just needs, the science is going to need to catch up to it. The identity of the region is going to have to be really clearly defined. And then you're going to have to figure out the genetic stock that works there and then tailor the plant specifically to be receptive to that region and that environmental factor. But I think that can be done. It's just, it takes time, takes resources, takes the research, takes the dedication. So I mean, this is one of the reasons why I'm really excited about it, because I think these things can grow into it, but it's not going to be, if anything is figured out within the first 5 years where we're like, we figured it out, I am going to be so surprised on this.
Yeah.
And then also probably skeptical.
Well, and one of the things that I've observed over the period where I've been, let's say, smoking weed 50 years. Okay.
Yeah.
Um, is that it used to be that what we got in quantity was just grown naturally. People weren't trying to selectively grow it, and it came from, say Mexico. They just grew it, cut the tops off, press it up, and we got seeds from it. They
Right.
grew them up here, and it was crap weed. But what we've seen when prohibition really came in is people go hide. And
Right.
what you grow when you're hiding is much different than when you're growing. When I'm commercially licensed to do this, how do I actually make a profit? And I try to warn people now that want to go grow indoors. It's like, well, that's not a long-term sustainable model, because the sunlight's free.
Right.
Okay. And in 10 years, when the strains being grown in, or strains, there we go again, when the plants being grown indoors are going to be very minuscule, the long-term plan is we have soil, we have sun, and perhaps we have some unique cultivars here and our own little techniques. That's where the big market's going to be. And today, every time it's enforcement, they go hide in the shade or put it in a building.
Right.
So I don't know what you make out of something that comes out of a building and it's got 30% THC and they're blowing the hell out of it to market it, when in 10 years, perhaps they're going to step in and say, we're going to limit THC like they did with alcohol. 151 is as much as you can get. Beyond that, we don't want to go in there.
And the Dutch put forth that proposition. It didn't catch on because I think the enforcement looked like it was going to be a nightmare.
Mm-hmm.
But they proposed that as well. And I think it was, if you go over, this is a little bit arbitrary, but I think it was around the number of 15%. Anything over that should be considered hard drugs. And because they have the concept of hard drug, soft drug. But then it was like, how do you really get in to do that enforcement? But we don't know. And this is the other thing, planning for the end of prohibition when we have no idea how the federal government is going to handle this, or how we start to have some sense of consensus so we can have interstate commerce, and what the product looks like in California is still a similar product when you get to New Jersey. We don't know how this shakes out. So planning for that, I mean, if anything, I just have it as this is going to be a massive shift. There's going to be a lot of paradigm shift. There's going to be a lot of legal shift. I think for the idea of indoor cultivation, long term, it doesn't show itself to be as efficient, but I think there will always be a place for it in the marketplace, because I also think that there's things you can do with cultivation of the plant in a controlled environment that you can't do when it's outdoors and it's engaged more in the environment. And it's subject to did we get a spike in freeze, or did we get a random hailstorm or extra rain this year? So I think there's always going to be a demand for it. And if we have an acknowledgement of full plant medicine as medicine by the FDA, it's probably going to require indoor cultivation. I think that, from what I've seen in the Netherlands and what I've seen in Canada, you want a controlled environment with no possible room for contaminant. If you're going to, especially we're talking about this in the sense of a formal medical good, because the US is not going to lower its standard for plant medicine to make this accessible. So I think there's always going to be a marketplace for it. Also, it might just be used for, if you want to produce high yielding hash in many ways. You can really juice the plant in a controlled environment. So I think there's utility there, but I think predominantly what we will see at post-prohibition is outdoor cultivation or mixed light cultivation. So I agree.
Well, with that. I'm certainly looking forward to an ideological lessening of the in loco parentis response to beat the shit out of you and throw you in prison for daring to use drugs.
Right.
And when Oregon finally stepped up and said, let's take the low hanging fruit off the table.
Yep.
The people that are that are having troubles with meth should not be thrown in the system. Look for the people that are cooking the meth. Right. What I'm seeing now is that I have 5 grandkids, okay, and they don't buy the bullshit anymore. Okay. Right. I still have to deal with a lot of people that are my age that buy the ideological nonsense. But I'm getting some traction now with even conservatives that, how do you justify the amount of money and resources you're putting into someone smoking a joint. I mean, really. Or somebody who wants to take some mushrooms, or, we used to take peyote buttons and make chocolate milkshakes and play poker all night.
There you go.
Okay.
All right.
I mean, if you're going to say I'm successful, I went to law school and, I was successful. It didn't burn me out. And the same story with LSD. You take this, you're going to have 3-legged kids. And we're all going, well, you used to fry with me and your kids look okay. People don't buy the lies much anymore.
And that,
so I'm very hopeful that we're going to get the business-minded folks to stop the ideology and look at this more as a business, because we're not going to change the corporate laws, at least not drastically real soon. And we've got to move this into a place where everyone is looking to make it work, rather than we're going to squeeze as much money out of this as we can before it gets to the consumer, which is it's a neo-prohibitionary stance that is still being taken.
And I'm all about drug policy reform. We've talked about this a lot in the past. I think that the United States, the persecution of people for doing something in their body that is not harming other people is absurd. I think it should be looked at, especially if they're harming their body, as a public health safety issue, and you should be able to get assistance for that. You shouldn't be shamed for it. You shouldn't end up with this felony that's going to follow you, where it restricts what job you can have, education you can pursue, or places where you can live. I think it is fundamentally antithetical for our concept of sovereignty and freedom to think that somehow we're bettering someone by incarcerating them for doing that to themselves. Mm-hmm. I do understand, I mean, prosecution, especially for volume production of drugs, especially because that's usually not an isolated thing, that usually goes hand in hand with other criminal activity, or oftentimes does. I can understand that, and I think there needs to be enforcement, especially if we want people to be safe in what they're using. But I do agree, the United States, especially younger generations, I think the boogeyman has kind of been, cracking an egg into a pan. I grew up watching that. Like, this is your brain. Yeah. This is where you're going to end up. Yeah. That has been put to bed, and there's more questions that are being asked, let alone looking at plant medicine. Something along the lines of, we'll say, psilocybin, right? That has had cultural components for many different cultures. It's a naturally occurring plant that's been around or fungus, different than plant, that's been around forever because it's natural. And looking at this and being like, well, hold on, people have actually been saying they benefit certain things. And the US has been so adamant about putting certain substances up on a shelf and saying anything about that is just going to mess up your life, mess up your body, mess up your brain, and you're garbage if you take it, creating a second-class citizen because you're a drug user now. Mm-hmm. And looking at these things and saying, well, maybe there actually is some utility in these things. I mean, the fact that cocaine is a Schedule 2, where cannabis is a Schedule 1, and the absurdity there is, well, let's look at these. And then to think that there's still utility in cocaine for doing eye surgery.
Of course there is. It's a wonderful anesthetic for the nose. When I worked in the ER, if we're going to do anything with the nose, we had a device that could squirt, 6%, whatever it was, cocaine solution in there, and it went numb. We could go in there, manipulate things for them. The same thing with the eye. You can put it in there. You can do eye surgery. Okay. Right. Now, what I try to remind my ideological on the right people is that they found evidence of coca and tobacco in a tomb in Egypt 1,000 years BC. Right. Okay. Cyprus was growing opium poppies like crazy.
Right.
So we go clear back to then. Somehow it got from the Americas, because it was a new world plant. It got to Egypt, and the Mediterranean basin was a hotbed for this, because human beings figure out, if I eat this mushroom, I go transcend with God, or whatever they did. It's like, it's like having sex. We're hardwired to do this. If you make this against the law for what we're hardwired to do, you're creating an entire second class of citizens. And I know, I went to prison for this. What I learned is that we send too many people to prison because we're mad at them.
Right.
Like, I told you not to do that. You did it. I'm going to throw you in prison. As opposed to, we should be afraid of you. you're going to lie, you're going to cheat, you're going to steal, you're going to hurt somebody. That's where we need to reserve those mentalities. And even then, unless you are hopelessly, going to kill every time somebody takes their eye off of you, I believe in redemption too.
Yeah.
So,
I think,
I'm just happy to see this, because for those of us who have seen loved ones die from overdose, and I, my girlfriend died, I was doing CPR on her in the ambulance
right,
from an overdose. It's like there are victims here to this, that it's not a moral failing if you struggle with substances.
right.
No. And we need to get way, way beyond that and move into accepting that people will do certain things. If there's a public safety component, cool. But smoking a joint and an hour later driving yourself home, it's not like I just chugged 3 shots of whiskey and I'm getting in the car right now. The disconnect is, the criminal justice system is a horrible way to try to deal with human behavior that's not hurting other people.
And I think the way that we have legitimized this or rationalized it in the States, where tobacco and alcohol, permissive, legal. I grew up in Wisconsin, where, I mean, there was jokes of, until you either break up a marriage or lose a good job, you probably don't have an issue with alcohol. Or if, you only got 2 DUIs, it's not a problem.
Your third one says you got a drinking problem. Yeah.
That's it. Right. And I think the fact that is, even though that's absurd, like that you can have a problem without any of those things, but that normalization of it, or smoking cigarettes. I mean, evidence shows that's probably, you stretch that out long enough, your probability of having lung cancer or other assorted pulmonary issues is very real. But that's your choice. If you want to do it, that's your choice. To see that we haven't extended this to other substances, and then make them safer, or make the opportunity to have support, is just really absurd. It's an archaic system that is premised on a lot of boogeyman scenarios of, well, there is a moral failure, or especially we're going to target people of color because this is an easy way to police those communities. That I think that there's a shred of change that I do see on the possible horizon. I'm optimistic of it. Specifically, the last presidential debate, there was some words spoken by Joe Biden where he normalized substance issues in a way that I think the United States needs to hear right now. Because for being 40, I don't really know many people who can say that they don't know anyone in their life who hasn't struggled with some form of substance abuse, especially as it relates to pharmaceutical drugs and alcohol. And with that, I think that talking about this in a different paradigm and not seeing someone as less than, it's just, oh yeah, you're not going to say, well, you've got cancer, so you're less than, or, you're terminal with AIDS, you're less than, or you've got diabetes, you're less than. And I think we need to have a paradigm shift where we're talking about it more at that level for people who have substance abuse issues. Because from my experience, especially with people I care about who I've seen that they have this, there's usually, that's a secondary issue to what's going on in their life. There's more of an underlying issue, especially as it relates to mental health, depression, feelings of isolation, and
childhood abuse,
and trauma. Working through childhood trauma, like the amount of psychedelic experiences I've had in my life, where having someone start opening up about what happened to them growing up. And I think that this is why I'm optimistic about looking at these tools for a way to address and actually work through, instead of just cover up and push down. And I think that push down situation through a lot of pharmaceutical drugs, you're just going to carry that with you your entire life. And you're being proposed that here's a Band-Aid and just that's the best you get. Maybe you get some mental health or some therapy sessions with that. But I think that there are aspects of psychedelics that allow for an opening up of old wounds and look at them in a way that needs to be honored and needs to be addressed. And I think there's a reason why there are cultural traditions outside of the US culture that have held on and preserved these, because it's a tool that can be used, especially used in the right way. And I am optimistic that we're at least having a paradigm shift or an openness where we're willing to explore these more and have a new conversation instead of just putting it up on the shelf and saying, well, clearly that's what's ruining society and that's what's bringing it down, instead of saying, well, it's part of society. Let's look at how it might be best utilized, or maybe we can create a structure that allows for it to be more safe for people and more accessible.
Well, my father-in-law was trained as a psychiatrist from the end of World War II into the early 1950s. And they were just beginning to do psychedelic research. And over the 50s, they've just found scads of evidence that the naturally occurring hallucinogens and LSD were wonderful antidepressants. I mean, there was a plethora of evidence being gathered. And then as Nixon decided that we're going to stop all this stuff, hallucinogens were put into Schedule 1, just like cannabis was, for nefarious reasons.
Right.
So now physicians are going back, researchers are going back and dusting this off and trying to pick up where we left off. Because when you read the research about the SSRIs, and they were no better than placebo at dealing with depression, unless you've got really massive depression problems.
Right.
If you go into the areas, let's say, where ayahuasca is used, and you have shamans that guide you, those were traditional practices that kept your brain circuits and brain chemistry back in balance before they even knew what they were doing. And rather than getting it way too far into the spiritual and esoteric part, this has chemical implications in your brain. We can measure, we can study it. Let's see how we use that. Because I remember when they took away cannabis from me and they stuck me in opioids, they passed me through every damn antidepressant you can think of, just OxyContin and morphine, and now here, take Prozac or take this other stuff. It's like, my God, you're going to kill me. And what I wanted to do was smoke weed and every once in a while microdose some psilocybin and keep my head straight. I was run through a knothole. So I have personal experience that irritates the crap out of me, that rather than torture people, allow physicians to be open-minded about this, a pathway where, we're not going to give somebody something that's poisonous, but allow this to open back up. And I was just so happy to see Oregon go, stop this nonsense. California, through our legislature, there will be a psilocybin bill. Scott Wiener's already talking about putting it forward, and we're going to lower some of these boogeyman barriers and maybe bring some real health back to people.
I think for the idea of sovereignty and freedom, we should be able to especially explore inward as much as we want to, and ideally in a safe way and in an environment that has a society that supports both the expression that I want to have outwardly and the exploration that I want to have inwardly. And to have a government say, you don't have enough agency that you are able to explore that always has been a conundrum for the concept of sovereignty and freedom for me. And I think especially along the lines of looking at how we can help people. And I remember my experience when I moved to the West Coast when I was 21, and I had my first experience of seeing medical cannabis, because there still is no such thing like that in Wisconsin. And meeting the first person who could say, this is what this does for me, where I'm not taking pain meds. And the light bulb went off, and it just makes sense. And now having met more people, we're being like, you get to pick how this helps yourself, instead of just being told, this is what you have to do because it's compliant with your insurance. We need to look at that, and we need to honor people. We need to honor choices. I think safety is obviously a paramount concern, but I think there are ways to do this. I mean, I lived in Amsterdam. They had classically in Amsterdam, they selling psychedelic mushrooms, right? And then they had a 16-year-old French girl jump off the Nemo Museum while she was tripping. And so what was their rationalization for how to handle this? Well, we're going to stop selling dried mushrooms because it's harder to gauge the dose of psilocybin in a dried mushroom, but we're still going to allow for the sale of truffles because it's lower dose and it's easier to manage. And I think that sensible, so it's not taking it out of the society, because it's going to either you're going to create an illegal subculture it's still going to be there, but you have to police it now, or you're going to be responsive to it and say, well, let's make it safer, because we can make it safer.
Mm.
And I think the United States is starting to acknowledge that we can do this better. And I know here in Oregon, I voted for it. I think there's going to be some friction with the paradigm shift. I know that hospitals are going to have to respond to this in a different way.
Mm.
But I also know that most of the nonviolent drug crimes are matrixed out because the system's so overwhelmed anyhow. So you're just not going to get stuck with a felony. And that, I think, allows then for, well, maybe you can get your life back on track if you need help. Or if we draw the idea out farther, there's going to be a system in place that is funded by the state, and we do have resources where you can actually get the help you want. And that's, I think people just need help. That's the reality of this. And instead of saying, well, you just can't do it, as opposed to, if you're doing it and you need help, we can help you. I mean, one of those sounds like a much more supportive government system than the other one that's just saying, well, your choice now makes you a second-class citizen.
Well, and in the war on drugs, drugs definitely won.
I
stuff.
think here it's like it wasn't even a war. They made a war out of something that people were just doing. It's like saying the war on alcohol. The war, like, I became very hyper aware this last rotation of living outside the country, how much the United States loves to use the word war, and how much we identify with it as just that is a cornerstone of our identity, of who we are as a people. Now, when you casually talk about that with people from some other countries, it freaks the hell out of them, because the concept of war for them, especially in countries that are either ongoing with military conflict internally, that's not a sexy concept to talk about, or that's not an overly strong concept to talk about. That's a problem. That's where people are dying. That's where there's strife. That's where there's immense violence. Yet we talk about this in a more casual tone of like, oh yeah, this is a byproduct. This just happens. And that, I think we would be better served if we kind of analyze that and looked at it as a cultural identity. Is this really even just benefiting us, instead of just looking outwards and saying it's benefiting the world? But is it really benefiting the United States as a whole? Especially, I mean, you're a vet. You know this. You've been, like, how many vets after the fact would talk about how amazing. I mean, I know my grandpa went through World War II. He wouldn't talk about his experiences. And I think that is the reality, but we have become so casual about how we use these words that it's a detriment. And then it's also, I think, kind of slap in the face of the people who've experienced it firsthand.
Well, we have not had war in the United States, and that's why we play around with this. You go to Europe, they were destroyed. They were destroyed by that. And we're just not a mature enough civilization yet to have that as clarity in our thought, because the Civil War was turned into all sorts of propaganda bullshit we deal with today. But you're right. I was in the military during the Vietnam War. Active combat was down, but I saw the effects of warfare, and it's not funny.
Right.
It isn't a car accident. You know, I saw people napalm burned halfway through their arm, little kids all, you know, there's stuff you see you cannot get out of your head. I don't like that term, but we're sort of cavalier in this country. We think we can do and say any damn thing we want. You know, and I can remind people that my mom let me be only so petulant in public before she slapped the shit out of me. And people just don't understand. You can get people so upset with the expressions of your stupidity, you know.
And I think it's interesting, especially to like say and do anything, because I lived in China for a few months, and I lived in an environment where the concept of freedom of speech was not there. And it made me respect freedom of speech that much more. But it also showed that the power of the words that you use to create your reality and then create your community are so much more important, because the inverse to that is the government is going to tell you how it's done. And that is one of the things that I think is really great about our country. But I also think that there is an abuse that sometimes goes along with that, or people don't understand really clearly what the value is. and just this misconception that, oh, it's like this everywhere. It's not.
Yeah.
So I would like to see things moved away, and let alone, I believe that, one, I love our country, but we are also a planet where there's people all over. They may look different, sound different, but we're all people. And I think at the end of the day, we're all suffering, and we want to get through with a little bit of happiness, connection, love, positivity, right? This is what I've seen from my travels around the world. And I think that if the US could dial back the concept of how we use war significantly, we would be creating really beautiful relationships around the world, and maybe we would be leading for some things that maybe potentially have more virtue to them than just through a military presence. And I would like to see that as our future, and that's what I'm hopeful for, and that's what I try to contribute my positive energy towards. But and I do think that we're trying to move away from it. There are some people who want to hold on to it, but I don't think long term that's the answer, because at the end of the day, we're all just people on this funky blue ball of earth, floating through space, just trying to get by, man. And that's just what it is.
Yeah. Okay, Luke, we could go on for weeks about this stuff. So listen, as always, thank you, buddy. And I'll be calling you with my intellectual property problems.
Either way, Dale, I like talking to you.
I have a really quick question. So I had to step away for a second, but I was listening to the whole thing, and this has been an amazing conversation. So thank you so much for contributing. What if somebody is in the is getting themselves set up in the cannabis industry, and they are trying to decide the who, what, when, where, and why of getting themselves trademarked for their brand? What is your best piece of advice?
One, talk with an attorney earlier than later. Don't just trust designers. That has been problematic from what I've seen. And I'm not even going to I'll shamelessly plug myself. You can contact me. Look for Luke Zimmerman Cannabis if you're doing a web search, or Luke S. Zimmerman Law Office. Luke S. Zimmerman, I think, is my URL, or Cannabis Law. But outside of just trying to say this for myself, look at the International Cannabis Bar Association. There's plenty of really talented attorneys there, but find support, especially as I said, it relates to intellectual property. It's usually not intuitive. It's something that if you got to work backwards, it's harder. So if you're contemplating these things, but when I teach my Oaksterdam section, what I stress is I just want you to be able to identify that's intellectual property. I then go seek help. Don't try to figure it out on your own. Some of the things you can maybe do on your own, but if it does hit some hiccup, trying to sort that out is probably going to be outside of your skill set. So that is money well spent. Yeah, and I just Dale, I want to also say thank you to you for when I was trapped in Italy and isolated. You were so amazing to me, and especially talking about trauma and PTSD and being in a position where maybe you are resentful and pissed off that you're trapped in a situation that you really don't want and you didn't want to choose. Your words especially, I knew were authentic. I knew they were true, and I knew that you you could relate to what I was going through. So I just want to say thank you for that. That really meant a lot to me.
As always, Luke, thank you. Love you.
Love you,
and
bud.
we'll be in touch, okay?
Okay.